understand the charge?
Yes, sir.
Mr. Watson?
Thank you, Your Honor. May it please the court, I've had a chance to discuss this matter with my client. He's prepared today to waive the final hearing, admit guilt, and proceed straight to sentencing, Your Honor.
Is that what you want to do, Steve?
Yes, sir.
Or what's your plea to that charge?
Guilty.
All right, I'll accept your guilty plea and find you guilty. So what do we do now?
Well, Your Honor, I went from the woods to a little more sane, to a little more sane, to a little more sane. And I reverted backwards a little bit when I got a job. I started working for a city councilman and I thought I was doing the right thing by doing so. But because I wasn't in the environment that I actually was placed in, I wasn't really prepared to have money and be in a situation where I'm back around the same people. And I left myself very vulnerable to my own failings. And by not being in the sober living environment that I was placed in already and coming back to Painesville, I put myself in a position where I'm working, I now have money, and I'm around people that I shouldn't be around. Even if they're people I don't know, they're still people I shouldn't be around because I'm not prepared for the situation. And I'm hoping that you'll allow me to go back to square one, where I did complete the inpatient program, but I did not complete the sober living. And this time, per my probation officer, I would like to complete all of their services all the way through. The sober living, the IOP, the inpatient, and keep up with my signature health, mental health caseload as well.
So what did you do last time we were here? Where did you go? You went to square one, right?
Yes.
How long were you there?
I was there for 50 days, roughly.
And
maybe
then
60.
where did they want you to go after that?
They had me in a sober living environment, and I had this ingenious idea that it would be better to do sober living in Lake County, around where I'm going to be actually living in the end. And that, in turn, was not such a bright idea. It left me not prepared. It left me around.
Did they want you to go to somewhere in Ashtabula?
Yeah, they had a place I was in Ashtabula. Like, if I go there now, I'll be at square one for 30 days, and then they'll take me to a sober living environment that's still in Ashtabula, which is where I'd actually rather be, honestly, and where I'm thinking about relocating in the long run anyway, because I'm having trouble finding housing out here as it is for me and my family. So it's been really, really difficult to find housing in Lake County. Nobody will rent to me, and I'm trying to get a real job again. Like, I have been working out really hard to get my health back in order. I haven't had a real job in quite some time. This working for the city councilman was the first time I've had a real laborer's job in 12 years, and I was able to keep up. And I did good work. It was just put cash in my pocket, and now it's not a good idea for me.
Did you, were you still going to square one for the mental health stuff?
Signature?
Signature, yeah.
Yes.
Okay. Did they have one of those out in Ashtahoozits?
They do.
Okay. All right, when's that going to be ready, Bill?
Your Honor, the bed is going to be ready tomorrow by noon, and then Erin Mayer, the social worker at our office, is available to pick up Mr. Payne directly from the county jail and transport him directly to square one.
All right. All right, I'm going to continue you on community control. How many days have you been in, Jennifer?
On this probation violation, 29.
I'm going to give you 30 days to jail, credit for 29. Going to be released on June 13th at noon to a representative of the Public Defender's Office. He'd be transported to square one to complete their inpatient program, and then when you finish that, you're going to go to the sober living facility that they recommend. And then the other terms of keeping up with signature, the doctor and dentist limitation, medication limitation, and costs and fees will stay in effect.
Thank you, Your
And
Honor.
then I think, when is that set in Muni, Bill, do you know?
Off the top of my head, I don't. When is your Painesville case? I think?
They didn't tell me. I went
Okay.
on the 10th and
Jennifer?
when,
It's 17th, I believe.
Okay, so they'll transport you to take care of the Painesville stuff.
okay.
All right, anything else? You understand everything?
Yeah, I just, like I said, talked to you about the bond. That's the only thing I didn't know about. But I didn't want it to get in the way.
Mr. Payne's question, Your Honor, deals with, he thinks there's a bond in Painesville that might interfere. I don't think there is. I'll call Painesville Municipal Court as soon as I leave here. But there's no warrants, and I think he'd be free to go tomorrow, so.
All right, if you run into a problem with that, let me know,
I
okay?
certainly will, Your Honor.
All right, Steve,
Thank you, Your Honor.
go do what you're supposed to do.
Yes, sir.
Payne?
We were last here May 1st when the defendant pled guilty to 1 count of aggravated possession of drugs in each case. The defendant has 110 days of jail time credit on case number 24, CR 00318, and 104 days of jail time credit on case number 22, CR 001056. The state is requesting a 9-month prison term concurrent on each case.
All right, Mr. Williams?
Yes, Your Honor. The only correction I would make to that, I believe the 110, just for purposes of the record, the 110 days of credit, I believe, would be on the 22 CR case as opposed to the 24. He was taken into custody on the outstanding warrant on the 22 case when he was apprehended on the 24 case, has been in jail in lieu of bond in both those cases. And on the 22 case, the 110 comes from the 6 days that he served pre-indictment when the case was filed in municipal court. Your Honor, as far as both of these cases are concerned, I mean, they're both low-level drug offenses. That's not to demean the series of these offenses, but that's just to say that Mr. Morgan is, a drug addict. He will be the first to admit that to you and tell you that. Substance abuse is something he's struggled with, heavily for the greater part of his adult life. To his credit, he has been able to maintain consistent employment throughout this period of time and be productive. He is a laborer. He's been in business for himself for a number of years, doing drywall and various construction work.
Local 95 carpenter.
So, carpenter. So he is someone with a skill set that can contribute to society and, can provide for himself. His biggest thing is just going to be remaining clean and sober. As the court is aware from the mental health assessment and substance abuse assessments that were conducted, Mr. Morgan does classify as a dual diagnosis person. He has suffered a number of incidents in his life, traumatic incidents, including most recently the murder of his fiancée and the passing of his brother, who he was very close with. And those two things had a profound impact on him in terms of relapsing and led to the trouble he found himself out in Ashtabula County. As the court is aware, Ashtabula County did place him on community control sanctions at that time, finding that he was amenable to community control and to treatment. The hope of that court was to put him into NeoCap. Unfortunately, there were some other individuals in NeoCap that the court was concerned about Mr. Morgan being around for that purpose. He was held until a suitable CBCF facility could be found to place him in. Eventually, placement was found for him. He was doing well in there. Actually, was placed in the honors dorm at one point in time because of the progress he was making, and he was kind of an example for the other people in there. Unfortunately for him, he did develop 2 staph infections while he was committed to that CBCF. He had to be treated for those and taken out of the facility, was placed on medications that unfortunately resulted in him relapsing and essentially going on the lam, and kind of going back to his old ways until he was apprehended here on these cases, Your Honor. Mr. Morgan's 51 years old at this point in time. There's no other time than now he's going to have to try to get this, squared away. He understands the clock is ticking. He doesn't want to continue to lead the life he's been leading. He wants to get clean. He's going to be accepting of treatment. He wants treatment. Based upon the assessments, it appears that NeoCap is willing to take him, and there obviously were several recommendations made in the event he were to be placed in community control as far as taking place in a dual diagnosis program, sober living if he is, given residential treatment, and I find all those recommendations to be suitable and quite frankly necessary. We can, any prison time that the court would place on him in this case, he's been there, he's done that. It's not a matter of doing the time. He can probably do the time standing on his head at this point, Your Honor. He wants to get better, but he knows he needs the court. He knows he can't do it on his own. He needs to be in a confined setting. He needs to have, the watchful eye of the court over him once he's out of treatment to make sure he's following through with everything he needs to, Your Honor. Quite frankly, I don't see the harm in taking one last shot on Mr. Morgan. So for those reasons, Judge, we are asking the court to consider placing him on community control. We did have a brief conversation before he came in. I guess he received some correspondence from Cuyahoga County. Recently, I haven't had a chance to look at those dockets. He believes those holders have been lifted, so I don't know what the status of those cases is, Your Honor, but obviously he does still have the holders from Ashtabula County. Although Mr. Morgan feels confident that if he is given the opportunity to complete NeoCap, which is what that court was hoping to get him in the first place, then they may defer any judgments on the probation violations and allow him to complete the treatment that he needs. Thank you.
Thank you. Mr. Morgan, what do you want to tell me?
Judge, in 16, Lucci gave me 6 months on the condition, he just told me, just go do 6 months and get my stuff together. I got my stuff together, met a girl, high school sweetheart. Went back to work with my brother. My brother ended up dying of diabetes and drinking. I thought I could handle it and I couldn't. Got off my meds, I started drinking and using dope again. Caught a bunch of cases out there and then my old lady got murdered and I really went off the deep end. I can't handle it no more. I can't, without your help, I'll be honest with you, without your help, there ain't nothing but the joint for me. If there was a life sentence I could get right now, I'd rather you give it to me now than not give me treatment because I'm just gonna create more problems. You know, if I don't get help and I don't get my head right. You know, I got a beautiful lady behind me and 2 kids that love me to death. Why I got lucky enough twice in my lifetime to have women like that in my life, I couldn't tell you not one bit of it. Because they both, I met them when it was both at my bottom. And I don't know how to fix me. I don't know how to fix anything about me, sir. That's the bottom line. Every time there's a problem, I go medicate. You know, I fight through it and then I get close to winning like I did out at Oriana House. And then the dude put me on Vicodin and Percocets, or not Perks, but some with blue pill. But anyways, and it wasn't Viagra or nothing. It was some kind of painkiller. But that led to the dope that was already in there. And I mean, they were dealing dope everywhere in there. But I made it to the honor dorm and I pissed clean every month. Or, excuse me, I'm sorry. I peed clean every week, you know what I mean? But I went off the deep end when I got them surgeries. Or I'd been sober. I wouldn't even be here. Well, I'd have been here for the other case, I think. No, that was before that. But I can do it if I go somewhere and get my head together. You know what I mean? I can't get off nothing. I can't get on my meds and get sober at the same time. With a sober support, it's always the old friends and the new ways, or the new ways and an old friend or an old girlfriend or old something like that that's still using. And I don't know how to get away from it. The only way to do it is the way you guys say. You know, go to JTP or something, go to NeoCap, and then go somewhere. I want to go somewhere else after that. I don't want to get out, honestly. I mean, I'm scared to death. I'll be honest with you. I'm scared. I'm terrified. I've never done something like this sober. I've never done it. I've made it halfway and lost it every time. But I'm scared to death even worse to lose them. And that's the only thing I got left, are them kids. And I don't know what to do to fix myself. I don't know how to do it. I just know I can't. But I don't have the tools.
Where you've been to treatment before?
Oh, Lake House and CBCF in Cleveland, that's it.
Which one?
Which one, what?
Which CBCF?
It's the 31st. I think it's
Keating?
Fannie Lewis. No, that's where Lucci wanted me to go.
Was it
That's
the
probably in the
Keating's-
record.
Keating
That's where he
Center?
asked me to go when he gave me the 6 months. He gave me 6 months in prison, then we had to get done and just go. But
You're
what I'm
right,
saying
but I
is-
believe he did. The pre-sentence report indicated that in 2003, so over 20 years ago at this point, I think is when he
that's
last
what he
did
said.
NeoCap and completed NeoCap.
No, I didn't complete NeoCap. They brought me
Okay.
back. I had surgery, stomach surgery.
Why you got all these warrants?
Ashtabula is the one. Cleveland,
You
they
got a
just wanted to
Stark?
put, pardon?
You got a Stark County in there too,
Stark's a possession from 13, I
from
think.
19. But why,
19?
I mean, why are there warrants?
I don't know why there's a warrant still down there. That should have been taken care of. I was arrested since then down there.
Well, they exist.
Cleveland's gone. I gotta figure out a way to take care of, well, the NeoCap would help me with that too, wouldn't they? That's what they said, that lady.
Well, I mean, you got all these warrants because you're not showing up places.
No, I was in jail when they set that case.
Oh, shit, this stuff's from 19. Some of this stuff's from 19.
That's when I was in Cuyahoga, or Ashtabula County, sir. That was after my brother died. That's when I first caught those cases. That's why I didn't show up for that. I was in jail already. And they won't come up here to get me. It's within the city only, the warrant. I even filed a fast and speedy and they won't come get me.
I mean, I'm losing track of all this stuff, looking at this record of yours.
Cleveland's trying to make me snitch on my stepbrother, John King. I won't snitch on him, so they had the cases. That's what that was about. They got rid of those when Detective Little came out here last week and talked to me. He said he was taking care of that. Matter of fact, Little should be over there at jail now, waiting to talk to me about what he wants. But I'm working with law enforcement. I'm doing anything, everything, whatever normal people do. I'm trying to do, sir. Matter of fact, she was going to leave me if I didn't tell the truth and ask for and just tell the truth about the things they want to know and stuff.
Who wants to know?
Detective Little and the task force, math task force, whatever they call them nowadays.
For what? What kind of stuff?
They wanted me to tell on my best friend for having a couple pounds of meth in his closet.
Your Honor, I do know, just from notes I had previously, when he was sentenced in Ashtabula back in '21, he did have 578 days of credit, so we'd have to go back and do the math, but he was in jail there in Ashtabula County leading up to that for 578 days, leading up to his sentencing there.
And the only requisite there, the only thing Megan said she wanted was me to complete a CBCF and pay the $1,200 that I owe the courts. Other than that, they don't care. They don't care what I do. They didn't, that's why they had the warrant out for so long and never came and got me. They don't care.
Who? Which county?
Ashtabula. They're weird out there, sir. They do whatever they want. They're crazy. Call them now. They probably won't come get me. They're weird. All I want is $1,200 and for me to complete a program. A lockdown program. It's gotta be a lockdown program.
All right, Mr. Knopf?
Thank you, Your Honor. The state's requesting 9 months in prison concurrent on each case. The defendant's been to prison on 4 separate occasions. He picked up these new charges while he had another case pending. In the past 33 years, by my calculations, there's only been 3 years where he hasn't been convicted of another crime. That was 1992, 2005, and 2006. So again, Your Honor, of the past 33 years, 30 of those years he's been convicted of a new crime. The course of trial probation over and over, it's gotten us to this point. It doesn't seem like he's amenable to community control. So again, Your Honor, due to his criminal history, it seems that there's enough to overcome the presumption of community control in this case. Thank you.
Sir, I've only been on probation once. You can ask Kim. She went over with me in her office. 87 cycles I got in this court and I got pled guilty on every one of them. I was honest about every one of them and I went to prison on every one of them.
Why don't you stop doing all this stuff?
Because I don't know how.
Well, why
I
don't
knew how, I
you figure
wouldn't be
out
here.
how? What do you think? I'm gonna change you?
No, I think Neil Cap will. That's
Well,
what I'm
did-
told anyways. That's
did-
what Kim said.
Didn't you go there before?
No, I was only there 28 days, 27 days, and I had a busted ulcer in my stomach and it bled. It looked a lot worse than it did, so they took me to the hospital and left me there. And then I didn't report to Kim like I was supposed to.
When was
And then
all
they had to put a
this?
warrant out for me.
When was all this?
Pardon?
When was all this?
2003.
2003, I think.
Kim
Yeah, it
wasn't
was
here
when
in
my dad died,
2003.
2003.
Kim wasn't here then.
Kim Randazzo. Nicole, I'm sorry. I'm sorry, Kim.
Was
That's a
Nicole
big
here?
difference, too.
Was Nicole here in '03?
Huh? I couldn't hear, sir. Sir, I'm not going anywhere. If I'm gonna screw up at NeoCap, I mean, you guys just gonna put me in prison anyways. Can't we take a chance? I mean, I'm not going anywhere. I never do. I've been here for 50 years. I mean, if they want me, all they gotta do is walk down the road and
this
say,
is like,
hey, there's Dave. Does he have a warrant? That's what they do anyways.
This is like let's make a deal, isn't it? I'm Monty Hall. You know who Monty Hall is,
No, I don't
right?
think this is funny
Well,
at all,
You're old
sir.
enough to know who Monty Hall is.
The only thing I believe in, I'm gonna lose if I go to prison this time.
Well, Jesus Christ, Dave, you're 50, what, 51?
One,
51, you've been at this since you were 18, 17, right?
before that.
Before that, when you were a juvenile.
Just bad things happen. I mean, guy next door offered me $20 for every 3 crack rocks you drop off at 15, 14 years old. What are you gonna do?
Sound like Henry Hill.
No, that movie came out about 8 years later.
Okay. Well, it's kind of like Henry Hill, though.
Kinda, yeah. Pretty much, yeah.
Running money for,
My dad was a big shot in the unions through the sixties, seventies, and eighties. I mean,
where do you work, Dave?
I actually used to work for Acme Arsenal, but when Frank Russo and Jimmy DeMoro screwed all the unions and snitched on them all. Nobody's really doing union work right now. So I work for American out of Lorraine.
Doing
I'm just
what?
an estimator. I work on percentage and then salary. I make $670 a week.
Doing what?
Reading blueprints. I got a gift with blueprints. I can look
Like
at them. and read them
hand-drawn
without-
blueprints or CAD?
Pardon?
Hand-drawn blueprints or CAD developed?
Engineers drawings, footages, breakdowns, radiuses. Yeah, but no. 40 and Wygant did the addition to the back of this. I was the one that did all the drop ceilings. I actually came in with a felony and did those. Yeah, I worked at Calabrese Building downtown Cleveland, did all the radiuses. If you go in there in the soffits, when you first walk in the foyer, if you go into the courtrooms, there's a radius, just like the top of the tower, in every one of them courtrooms. I'm the one that figured out the radius, the math on the radius, chalked the lines and did the framing for them. That way I didn't get the curve out of it, look right in every one of them.
Okay, so were you doing that while you were using drugs or what?
Yes, heavily. Way I got my union card was I smoked crack on the weekends from Friday at 3 o'clock when they closed the gate at Key Tower until it opened up at 6:30 Monday morning. I ran footage the whole weekend. I didn't leave the job, didn't do anything. Packed a cooler, took beer, took dope, just ran footage the whole time. That's how I earned my journeyman's card. Vic Arsena, Acme Arsena out of Northfield, biggest union contractor at that time. That's what they did. They gave you free dope and stuff. You go in there and stay all weekend, so they didn't have to pay you union scale. All they do is hand you a card until you go find a job. That's all dead serious. Ask her. She was around.
You're a trip, you know that?
Why?
Huh?
It's true.
I know, I mean, you just,
Sir, I'm disgusted by it, honestly. After losing Crystal, I thought I was done. I tried to, I'll be honest with you, when I had the surgeries, got hooked on dope, I gave up. I wanted to go kill myself. And then I ran into her, and that didn't work. Her and the kids got in the way. I wanted to go get treatment then, but I didn't have the balls to face what happened to Crystal out in Ashtabula and go turn myself in. So I called Sheriff Walters. Well, he's Chief Walters out in Perry now. But I called Ronnie and asked him what to do, and he said to go turn myself in at Lake County. I went to Lake County, and it's Banjo, captain now, he was a lieutenant then, told me, what are you, stupid? They ain't coming to get you. They don't come get nobody. So I came to Lake County Jail, turned myself in on felony warrants for Ashtabula. They wouldn't come get me. Cleveland wouldn't come get me. Stark County wouldn't come get me. So I was stuck on the run and couldn't turn myself in. I'm dead serious. I'm not lying, not one bit. That's the problem. Ask the prosecutor. When you saw the videos, did I lie to them cops once?
so,
Did I lie to them cops once?
hey,
Oh,
over here.
any of them,
Over
Judge,
here.
any of them, any of the cops that have arrested me over the last 20 years. I have never lied to one of them.
Okay, so,
No, except for this last time. I lied about my name because I was too drunk to remember.
so you've done about, almost 4 months so far, right?
Yes, sir.
He wants you to do 9, at least 5 more, right?
Yep.
So you want me to send you to NeoCam?
Yeah, I gotta learn how to fix this or I'm
which
just
is
gonna be
probably
back here.
Which is probably gonna be 6 months.
Good. I hope it's 9. I'll go to Lake House too if you want me to. If it helps, send me wherever. The only way I'm gonna keep my family together this time is for me to do the right thing. It's on me. It's not on some guy taking over life with a bullet. It's not on anything but me this time. I have no collateral damage. I have nothing collateral weighing on it. All I gotta do is just do what you tell me. This is the first time I've had that chance in my life.
All right, I reviewed the pre-sentence report. It exhausted me reviewing that because it took so long. 87 cycles.
Can I say one more thing, sir?
Huh? Yeah, go ahead.
Kim?
Yes.
Out of all the garbage I did, have I ever lied to you about any of it?
I would say not.
Thank you.
And I reviewed the drug and alcohol evaluation. And I've considered the provisions of 29, 29, 11, 12, and 13. put you on community control for 3 years.
Thank you, sir.
155 days in jail, credit 110. Last 30 is a jail treatment program. Follow those recommendations. Meal cap. Follow recommendations. Lake or Concord Pines after that. Complete that. Follow recommendations. No drugs or alcohol on screens. Full employment. Pay the costs and supervision fees. Anything else, Kim?
And we're doing the same conditions on both cases,
Same thing,
Your Honor? Okay.
same thing. Except on the 24 case, it's gonna be, it's gonna be 104 days with credit for 104. Other than that, everything is the same. Anything beyond that?
Sign releases,
Oh, yeah. Sign releases so probation can get your records.
mental health,
So you got any diagnosis?
ADHD, bipolar 2. I think that's it.
All right, you get a mental health evaluation, follow recommendations.
She knows. I just take what they give me.
So there you go.
Thank you, sir. See you in 3 years.
Anything else?
Nothing further, Your Honor.
Nothing further, Judge.
Okay. You won, you got your deal.
Thank you, sir.
We'll see what happens.
Ain't about seeing, it's about doing. I'm finally ready to do it.
Can't argue with that.
Thank you,
All right.
sir.
Thank you, Your Honor.
day, but so, okay, so you've got you doing
Yeah,
the,
power
doing the
attorney,
JT.
just handling all with her.
That the defendant will be entering a plea of guilty to count 1, failure to comply with an order or signal of a police officer, a felony of the 3rd degree, and to count 2, obstructing official business, a felony of the 5th degree. The state has indicated that it will recommend prison at the time of sentencing. However, defense is free to request a pre-sentence report. At this time, there's no sentencing agreement, and that's the state's understanding.
Ms. Hibbert?
1 moment, Your Honor. Could I check my notes on something?
Mm-hmm.
One moment, Your Honor. Can I just tell my client something? Your Honor, that is my understanding of the plea agreement. I've gone over with Mr. Alston the rights that he'd be waiving by entering a plea of guilty, and I do believe he is prepared to change his plea today.
All right, so there's still one outstanding question here, though. Before I go through his rights, the advisement on PRC is going to be what?
Your Honor, the way it's written in the plea form is just advising him that it may be up to 2 years, and if the court determines count 1 is offensive violence, if the court is saying that they will not determine it's offensive violence, then it would revert back to the up to 2 years. There is an agreement on it, and he is pleading to the indictment.
Okay. So then am I being asked to make a determination at the time of sentencing whether it's a substantial risk of harm to persons or property? Because that determines whether it's up to 2 or 1 to 3, right?
Correct. The way the plea form reads is if the court determines that count 1 is an offensive violence.
I'm not, and like I told you guys, I'm not making I'm not gonna make a finding at sentencing.
Right, so if you don't make the finding, then it would be
Okay.
up to 2 years.
All right. Is that your understanding?
Yes, Your Honor, and again, being that he's pleading guilty to the indictment with no agreed sentence or agreed recommended sentence involved, and both parties are arguing, we would be taking the position that it is not an offense of violence, and therefore, if a prison sentence were imposed, there would be a discretionary period of 2 years of post-release control at the
Okay.
discretion of the parole board.
All right. Mr. Alston, how old are you?
34.
How far did you go through school?
I graduated high school and did a few years of college, and have my culinary license.
Are you a U.S. citizen?
Yes,
Are you able to read, write, and understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
You ever been diagnosed with or treated for any mental illness?
yes.
What have you been
PTSD.
diagnosed with?
PTSD.
Are you being treated for that?
Yes, I am.
What's your treatment?
I attend counseling at Murtis Taylor.
Any medication?
Yes, I don't have any right now, but I take Celexa
When's the last time you took it?
before I was incarcerated.
So it's my understanding you're going to plead guilty to both these charges, is that correct?
Yes, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. you don't understand a question or you want more time to talk to Ms. Hibbard, let me know and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, then I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes, I am.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes,
Are you waiving that right?
yes,
If you decide not to testify, nobody's permitted to comment on that decision. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
yes,
If you file an appeal, you have the right to have a transcript of all the hearings in this case. You understand that right?
yes,
Are you waiving that right?
yes,
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
yes,
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
yes.
You have any questions about any of your rights?
No, sir.
You still want to plead guilty to these charges?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, sir.
You understand by pleading guilty to these felonies that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
All right, in count one, failure to comply with the order of a, or signal of a police officer is a felony 3. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, sir.
And then count 2, obstructing official business is a felony 4. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
It's a felony 5, Your Honor.
What did I say?
4.
5. 12 months, $2,500 maximum. You understand that?
Yes, sir.
Now, if I sentence you to prison on the failure to comply, then a prison sentence on the obstruction has to be consecutive. Do you understand that?
Yes, sir.
If I gave you a maximum consecutive prison sentence, you face 48 months in prison and a $12,500 maximum fine. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
No, sir.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, I do.
What's the minimum, what's the range of license suspension on count 1?
Your Honor, it's actually for life. When you have a prior F3 failure to comply, it's for life.
Okay. So you're,
I didn't advise him of that, Your Honor. In all
Okay.
fairness, I would have to explain that to him.
all right, so because you've got a prior failure to comply, then the plea of guilty on this one will result in a mandatory lifetime operator's license suspension. Do you understand that?
Yes, sir.
Do you want to talk to Ms. Hibbert about that?
Yes, sir.
All right, go ahead.
Okay, thank you, Your Honor.
All right, you set to go, Mr. Alston?
Yes, sir.
Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Yes, sir.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, a parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of your sentence. Do you understand that?
Yes, sir.
Do you understand if your violation is a new felony, you could get an additional consecutive prison sentence for that violation?
Yes, sir.
If that happens, the maximum prison term for that violation would be the greater of 12 months or the time left under post-release control, whichever is greater. Do you understand that?
Yes, sir.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any condition, then I could send you to prison for 48 months. Do you understand that?
Yes, sir.
Has anybody promised you I will be lenient on you just because you're pleading guilty?
No.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Ms. Hibbard before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
Would it, if I was able to get a job that required some driving, could I get privileges for work, or I
No,
couldn't even get
not,
that?
not that I'm aware of. A mandatory suspension, I don't believe it would allow for any driving privileges.
I believe you can get privileges on a failure to comply suspension.
Look, I don't have any idea. Okay, I don't know. If it's a mandatory suspension, my guess is no, but
It does say in the statute, the court shall not grant limited driving privilege to the offender on a suspension imposed for felony violation of this section.
okay. So I don't think so. It seems like you would not be able to.
Okay.
So he can never drive again.
That's kind of that seems to be what the statute says.
It seems like an enhanceable penalty that a defendant should be advised of at the time that they enter their plea to the initial failure to comply, just
Look,
like an
I don't
OVI,
have the
but
slightest idea
I
what
just want
happened.
that on the record.
Okay, so does he want to plea or does he not want to plea? Well, I tell you what, why don't you take 5 minutes and then let me know and I'll come back, okay? the enhancement, you believe is the lifetime suspension?
Yes.
Is there any other enhancement?
Well, it becomes as opposed to a, if I recall, and I just read the statute, a cursory reading of the statute without doing any research on the case law suggests that you can also not get driving privileges.
Right.
And yes, yes.
So if he pled guilty and after he was sentenced, you appealed the lifetime suspension with no possibility of driving privileges, would you not be able to appeal that to the Court of Appeals?
Well, I want to make it part of the record that, I'm not sure, because if he's entering a guilty plea as opposed to not contesting the facts as alleged,
Well, the fact is alleged is that he's got a prior failure to comply, right? Which he does.
yes.
Okay. So that fact is true. The only issue is whether that should entail a lifetime driving suspension. You would have to, would you not have to get the record from the, where did he have the previous failure to comply?
Working on it, Your Honor. I have already indicated to my paralegal we're going to have to order the plea and sentencing ASAP.
Cuyahoga County.
Okay. So your belief is if he pled guilty, and my guess is, I don't know, who the hell knows what he was advised or not advised in Cuyahoga County, okay? If your belief is if you appealed it and he wasn't advised that a subsequent failure to comply would result in a lifetime driving suspension without driving privileges, that would be in effect ineffectual and he would be able to get driving privileges here, right?
Yes. Well, I think that it would affect the validity of his previous conviction, such that
So
it,
you would think that you can get the conviction of the first one vacated because he wasn't warned that he could get a lifetime driver's suspension on the second one?
No.
That it wasn't knowing, intelligent, voluntary?
correct, it would be akin to an uncounseled prior OVI conviction, which the law,
Which doesn't allow you to enhance the penalty,
correct,
right?
correct.
Your Honor, even if it was just the first F3, he can still be, it's still a mandatory license suspension from 3 years to life. So he still could have gotten life and he still wouldn't be able to have limited driving privileges.
But it wouldn't be a mandatory lifetime suspension.
It would be mandatory 3 years to
Well,
life.
it would be mandatory whatever was picked by the
Correct, so
judge.
it could have been mandatory life.
Yes. Yes.
When did has that statute been in effect since the failure to comply statute?
Which,
The subsequent mandatory life?
that is underneath the failure to comply. It's in that
Right.
statute.
I know, but was that amended at any time after the failure to comply statute came into effect? Do you have any idea?
This one is effective September 28th of 2012.
Right.
So this has been since 2012, and it's under the failure to comply statute about
Right.
this one's at least since September 28th of 2012. So at the time he would have entered his plea, he could have gotten mandatory life, depending on what the judge said, it could have been
Right,
less without privileges.
but if he had gotten mandatory life on the first one, he would be eligible for privileges, yes or no?
No.
No?
According to the statute, can't grant limited driving privileges to the offender on a suspension imposed for felony violation of this section. Only for misdemeanor violation of this section.
So then your best case scenario is getting the other plea, whenever it was, vacated, right? in the hope that I give him less than a mandatory lifetime suspension, right?
Well, I don't know that I could get it vacated. I don't know that it would even be procedurally possible. I would probably then have to argue that because the sentence on that is served, so then I would have to argue that there are collateral consequences that he's still facing, which I'm not even sure that argument would pass muster. I really would argue it as it's akin to an uncounseled prior OVI conviction. And when there's an uncounseled prior OVI conviction, a subsequent OVI conviction should be treated as if it were the first.
Well, that affects the subsequent OVI, right?
Yes.
You're saying you have to treat that for penalty purposes as a first. That's
Yes.
okay. So procedurally, you would appeal this where? Let's say you pled no contest here. Then what are you appealing?
The sentence. Well,
But then they would say, well, he's got a prior failure to comply, and this requires the mandatory, so they would keep that.
but I would make it part of the record that his prior failure to comply was,
Don't you have to go back to Cuyahoga first?
no,
I mean,
it's,
11th could not act on this as long as the conviction in the Cuyahoga was still in place.
well, the 11th district could make case law that a prior failure to comply where the defendant wasn't advised that it was an enhanceable offense and a subsequent conviction could result in harsher penalties.
So you have to get the transcript and make it a part of this record? and
Yes, that's
show
what-
that he
Yes,
wasn't advised that a subsequent failure to comply is gonna result in a mandatory lifetime suspension, and there would be no driving privileges,
right.
or just a mandatory lifetime suspension, because that carries with it no driving privileges.
Right.
Okay, so,
And I might argue with an Eighth Amendment cruel and unusual punishment too, perhaps, but that I'll get creative with at the
look,
appropriate
you
time.
can argue anything with these guys, you know, and probably, depending on your panel, succeed, you know, but.
Well, it does seem a little harsh.
I don't know if it's harsh or not harsh. I mean, but that's, you know, that's for the legislature to decide what's harsh and what's not harsh. So we can't do this today, because I got a 3:30 and a 4 o'clock that are pleas and sentences. So what's your no contest take?
What was that?
I said, what's your,
Since it's to the indictment, it would be up to the court.
well, since it's to the indictment, I guess I'll do that, but because otherwise, we're gonna have a trial that we're gonna end up in the same place that we are, which doesn't make any sense. So, we can do that, just better figure out when we're doing it.
The no contest plea?
Yes.
Your Honor, would you be open to converting the July 11th sentencing hearing to a change of plea hearing?
That's too long.
Okay,
We gotta do this now because he has to be tried by June 30th. If for some reason we set up a hearing for a no contest plea and he decides he doesn't want to, he's gotta be tried by June 30th.
we could file a speedy trial waiver.
Well, I don't wanna screw around with this. I wanna get this in here as soon as we can get it in here.
When is the court available? I'm available most of the rest of this week. I have 1 or 2 hearings, if the court is available.
I I'm available tomorrow at 8:45 or 10:15 or 11:30. Or Friday at 9 o'clock.
I would prefer tomorrow, Your Honor, and I can do any of those times.
I have a visit at the Richland Correctional Institution scheduled for 8:30 a.m. tomorrow, and I have 2 suppression hearings in Allen County tomorrow afternoon. So tomorrow is really pretty much impossible for me unless I were to just cancel the Richland visit, which I would do because this is sort of attributable to the defense here, but I would prefer 9 a.m. Friday. I will make that work.
I can do 9 a.m. on
All right,
Friday if
9
need
o'clock
be.
Friday.
in lieu of conviction in this matter, and a report was generated on this court's order. I believe that has been delivered, and we are here today on that motion.
Mr. Hinton, as to the motion.
Thank you, Your Honor. We would ask that the motion for intervention in lieu be granted. I had an opportunity to read the reports that were completed as a result of the motion being filed. It's my understanding that Mr. Gladdy is eligible for intervention. I understand that there was a bond violation with a positive drug test for marijuana, and that Mr. Gladdy's been in the jail as a result. But nonetheless, we are asking the court to still grant the motion if the court was so inclined. Thank you.
State's position.
The state has no opposition to granting of the motion.
All right, I'll grant the motion. Mr. Gladding, how old are you?
19.
How far did you go through school?
What grade did you last complete? I can't remember. Was it middle school, high school? I can't remember.
Okay, he can't recall, Your Honor.
Well, I gotta have some idea, right? I mean,
It was like 10th grade.
Do-
He dropped out in.
is that right?
Yeah,
Are you a U.S. citizen?
yes,
Are you able to read, write, understand the English language?
yes,
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
no,
Have you ever been diagnosed with or treated for any mental illness?
no,
Did you get a copy of the indictment in this case?
yes,
So is it your understanding you're going to plead guilty to both counts in this case?
yes,
All right, now before I accept your guilty plea, I need to determine that you know and you understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be convinced that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you questions. If you don't understand a question, then stop me and ask me. Or if you want to talk to Mr. Hinton some more, let me know and I'll give you more time to talk to him. Do you understand that?
yes,
You have a constitutional right to have a trial either to me or to a jury of 12 Lake County citizens. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
yes,
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
yes,
Are you waiving that right?
yes,
If those witnesses refuse to come to court, then I'll issue an order that's called a subpoena to make them come and testify. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the right to testify at a trial if you want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you decide not to testify at trial, nobody is permitted to comment on that decision at the trial. Do you understand that?
yes,
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
yes,
Are you waiving that right?
yes,
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
Do you have any question about any of the rights we just went over?
No.
Do you still want to plead guilty to these two charges?
Yes.
Do you understand that by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies that if this case comes to a sentencing, that you're voluntarily giving up your freedom for whatever period of time that I sentence you to prison, to jail, or to community control.
Yes.
In count one, aggravated possession of drugs is a felony of the 5th degree, carries a maximum prison sentence of 12 months and a maximum fine of $2,500. Do you understand that?
Yes.
Count two, receiving stolen property is a felony of the 4th degree. It carries a maximum prison term of 18 months and a maximum fine of $5,000. Do you understand that?
Yes.
Now, on these two counts, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. That means you would face a maximum prison term of 30 months and a maximum fine of $7,500. Do you understand that?
Yes.
If you are convicted in count one, then I could suspend your driver's license for between 6 months and 5 years. Do you understand that?
Yes.
If you are convicted on any of these, either of these, then that would prevent you from owning or possessing a firearm. Do you understand that?
Yes.
If you are sentenced on these cases and a prison sentence is imposed, then when you get out, you might be on post-release control under the parole authority for up to 2 years. Do you understand that?
Yes.
They would place conditions on you. If you violate their conditions, they could send you back to prison for up to 9 months for each of your violations, up to 1/2 of my sentence. Do you understand that?
Yes.
If your violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that happened, the most you could get would be either 12 months or the time left on post-release control, whichever is more. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
You could be put on community control for up to 5 years, but if you violate the terms, I could send you to prison for 30 months. Do you understand that?
Yes.
Now, in a little bit here, I'm going to put you on an intervention plan with certain terms that you have to comply with. If you fail to comply, then your plan could be terminated, and then you would be convicted of both these offenses. Do you understand that?
Yes.
All right, and if that happens, then I will sentence you. Now, has anybody promised you, just because you're pleading guilty here, that I would be lenient at the time of sentencing?
No.
Did anybody promise you what I would sentence you to in this case?
No.
Do you understand if I sentence you, I'll get a recommendation from the prosecutor and a recommendation from your lawyer? Do you understand I don't have to follow either of those recommendations?
Yeah.
Have you had enough time to talk with Mr. Hinton before pleading guilty today?
Yeah.
Has he discussed everything about your case and answered all the questions that you've had?
Yeah.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Ms. Mulligan, if this case went to trial, what would the evidence show?
Your Honor, the state would show that on January 22nd, 2024, Damian Gladding was in a GMC Arcadia. He was arrested in the company of Kenyon Gibson. That GMC Acadia was stolen from Colin Kramer. Mr. Gladding had a reasonable cause to know that it was obtained through the commission of a theft offense because he was with Kenyon Gibson when Kenyon Gibson stole the vehicle. Mr. Gladding was arrested on that date, same date, and on his person, deputies retrieved a baggie that contained what was taken to the lab and tested, determined to be methamphetamine, a Schedule II substance.
Mr. Hinton, anything to add to those facts?
No, Your Honor.
Mr. Gladding, did you hear what Ms. Mulligan said the facts would show if the case went to a trial?
Yes,
Are those facts true?
yes,
All right, what's your plea to aggravated possession of drugs, a felony of the 5th degree?
yes, guilty,
And what's your plea to count 2, receiving stolen property, a felony of the 4th degree?
guilty.
Mr. Hinton?
May I approach, Your Honor? Should we execute this now, Your Honor?
Do you have any questions about this, Mr. Gladding?
No.
All right, if you want to plead guilty, then you need to sign that document.
Your Honor, Mr. Gladding's executed the document. His signature is below this.
Mr. Gladding, is that your signature on this written plea of guilty?
Yes,
Did you sign it voluntarily?
yes,
Do you want me to accept the written plea of guilty?
yes,
I'll accept the written plea of guilty. Defendant was present when Mr. Hinton advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge or consequence of his guilty plea and the maximum penalty for it to be knowing, intelligent, and voluntary. I will accept his plea of guilty to count 1, aggravated possession of drugs, of felony 5, and count 2, receiving stolen property, of felony 4. I'm going to stay the criminal proceedings and place them on an intervention plan. Go ahead, Mr. Hinton, as to the plan.
Thank
Anything
you, Your
want to
Honor.
say?
As far as an intervention plan goes, I understand that in the recommendation, based on the assessment that was done to Mr. Gladding, there was residential treatment recommended. However, I would indicate that because he has served 70 days in the jail, that we would suggest that he's ready for outpatient treatment. So what we would be proposing as an intervention plan is that he's released from the jail and that he participate in and successfully complete an intense outpatient program, that he attend 12-step meetings on a regular basis, and that he abstain from alcohol and drug use, along with the normal standard orders of this court as they relate to having only one doctor, dentist, and those sorts of things. Wouldn't have any objection if the court was to impose additional orders regarding obtaining a GED or attending school or work on a regular basis. Thank you.
Ms. Mulligan, anything you want to say about the plan?
No, we just trust the court to impose those conditions which it deems to be most likely to be successful.
All right, Mr. Gladding, what do you want to say?
Stay sober,
What?
stay sober, and attend everything. And I'm still working. Long John Silver's, a Menor. I'm a cook. And I'll be living with my dad. They're about to be getting a house.
All right, I mean, what kind of drugs you've been taking over the years?
Meth and weed.
All right, have a seat. All right, I'm going to place you on a 5-year intervention plan. You're going to serve 115 days in the jail with credit for 70. The last 30 days, you're going to be in the jail treatment program. Complete that and follow the recommendations. After you leave there, you're going to go either the Lake House or Concord Pines. And follow complete those programs and follow the recommendations. You're to have no drugs or alcohol and you'll be screened. Attend at least 3 AA meetings a week and get a sponsor. Get a mental health evaluation and follow all recommendations. Get your GED, a valid driver's license, full employment, pay the costs and supervision fees. Anything else, Mr. Tompkins?
I don't believe so, Your Honor.
You understand the terms?
May I have a moment, Your Honor?
There's no audience participation here, okay?
I believe Mr. Gladding understands those terms, Your Honor.
Is that correct?
Yes.
All right, if you violate the terms, the state will file a motion to terminate your intervention plan. If I find you violated, I'll terminate it and you'll be convicted of those 2 offenses. Do you understand that?
Yes.
If that happens, then we'll go to a sentencing in this case. You understand that?
Yes.
All right, is there any question or anything further, Ms. Mulligan?
No, Your Honor, thank you.
Mr. Hinton?
Nothing further, Your Honor.
cocaine, a felony to the 5th degree, in violation of Rides Code Section 292511 with a forfeiture specification. It's the state's understanding that the defendant will withdraw her previously entered plea of not guilty and enter a guilty plea here today, and a motion for intervention was filed. The state is not opposing that motion, and the defendant has 81 days of jail time credit. Thank you.
Mr. Hinton is to the intervention.
Thank you, Your Honor. As to the intervention, I had an opportunity to review the reports that were conducted and completed. It's my understanding that Ms. Kaminsky is in fact eligible for intervention. Appears that she has a short criminal history. I do think that certainly this is a qualifying offense. We would ask that the court grant the motion. I understand there was a bond violation and Ms. Kaminsky has been incarcerated as a result of said violation, but I think that intervention would be appropriate in this situation. Thank you.
As to the intervention motion, the state.
Thank you, Your Honor. The state is not opposing the intervention motion. Thank you.
All right, I'll grant the intervention motion. Ms. Kaminsky, how old are you?
38.
How far did you go through school?
I have a LPN.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
I have a medicine I take at the jail, but it's not a narcotic or nothing like that.
Have you ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed
I
with?
have unipolar.
Are you being treated for that?
No, I'm not.
Did you get a copy of this indictment?
Yes.
Any questions about it?
No.
Your intention is to plead guilty?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question or you want to talk to Mr. Hinton some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes.
You understand that by pleading guilty to these felonies, if you are sentenced, you are voluntarily giving up your freedom for whatever period of time I sentence you to prison, to jail, or to community control.
Yes.
Possession of cocaine is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
If you plead guilty to the forfeiture specification, you're giving up any claim you would have to the cocaine. Do you understand that?
Yes.
Do you understand if you are convicted of this offense, it may result in a driver's license suspension of between 6 months and 5 years?
Yes.
Do you understand if you are convicted, that felony conviction would prevent you from owning or possessing a firearm?
Yes.
Do you understand if you are sentenced in this case to prison, you might have to serve a period of post-release control for up to 2 years after your release from prison?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to happen, the maximum prison sentence would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes.
So anybody promised you that I would be lenient on you just because you're pleading guilty?
No.
If you are convicted, has anybody promised you what I would sentence you to in this case?
No.
You understand I would not have to follow the sentencing recommendation of either the prosecutor or your lawyer.
I'm sorry, can you repeat that?
Do you understand if you are sentenced in this case, I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Hinton before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Ms. Bell, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on May 27th, 2023, a car was pulled over in Menor, Lake County, Ohio. Ms. Kaminsky was a passenger of that vehicle. A search of that vehicle revealed that Ms. Kaminsky was in possession of cocaine. The cocaine was sent to Lake County Crime Lab and confirmed to be cocaine, less than the bulk amount.
Mr. Hinton, anything to add to those facts?
No, Your Honor.
Ms. Kaminsky, did you hear what Ms. Bell said the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
What is your plea to possession of cocaine, a felony 5?
Guilty.
What is your plea to the forfeiture specification?
Guilty.
Mr. Hinton?
Thank you, Your Honor.
Your Honor, the defendant signed the written plea of guilty. Mr. Hinton and I.
Ms. Kaminsky, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present when Mr. Hinton advised of all of her rights, being a knowing, intelligent, and voluntary waiver of those rights. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea. And plea of guilty to possession of cocaine and the forfeiture specification. I'm going to stay the criminal proceedings, although the item subject to forfeiture is forfeited to the state. As to the plan, Mr. Hinton?
Thank you, Your Honor. I know that normally in these types of cases, there's county resources, county treatment centers that are used. After we left Chambers, I had an opportunity to speak with this gentleman a little more. He's from the VA, and in this particular case, there's federal resources available if the court was inclined. There's a 30-day inpatient treatment center and some other things, and it sounds like this gentleman is, offer these services in similar situations. So I know that Ms. Kaminsky, being that she was, formally in the military, would like to take advantage of any VA benefits. And again, this information was learned to me after we walked out of chambers, but I wanted to suggest it, as I know it's different than most cases where we don't have that available. So there would be some additional tools available through the VA to assist in Ms. Kaminsky's intervention plan, including in treatment and then outpatient counseling and those sorts of things, Your Honor. She does reside in Elyria, and I know she's eager to get back to her children, has some college documents and things to accomplish with them. So thank you, Your Honor.
All right, Ms. Kaminsky, anything you want to tell me?
I've been meeting with Frank for a week now, or every week, once a week with him. We've been talking about going to the in-treatment thing. He said that he's able to be a sponsor for me for that. He can help me with IOPs. My kids are going to, my oldest daughter, she's going to college. She's using my GI Bill, so she does need my signature and paperwork. And then my other two kids are going to early college at Lorraine County Community College. They need my signature and their paperwork. Besides that, that's nothing else.
All right, I'm going to place you on a 5-year intervention plan. Sentence you to 126 days in the Lake County Jail with credit for 81. The last 30 days, you're going to be in the jail treatment program. You're to complete that and follow all the recommendations. Then you're going to enter into Oak House and follow all those recommendations, complete that program. No drugs or alcohol, and you'll be screened. Get a mental health evaluation and follow all recommendations. Get a valid driver's license. Obtain full employment, sign releases, and pay the cost and supervision fees. Anything else, Ms. Randazzo?
Yes, Your Honor. 3 AA meetings per week and 1 doctor, dentist, pharmacy sign releases.
I already said the releases. You understand the terms of the plan?
I think so, yeah.
All right, if you violate the plan, then the state will file a motion to terminate the intervention plan. If I find you violated, then you'll stand convicted of those, of that charge, and then be sentenced on that charge. Do you understand that?
Yes.
Anything else, Ms. Bell?
If you could just clarify the amount of jail time, Your Honor.
126 with credit for 81.
Thank you.
Anything else, Mr. Hinton?
So I have to do that.
Nothing further, Your Honor.